Well, hello again. This is part two, section two of the body of the petition for rehearing. The violation, systematic MABC, that's medical assistance for breast and cervical cancer. Very serious thing. Age bias violated the 14th Amendment. Age bias at every step informed all the actions of respondents and the courts below against us, that is, the patient and the spouse, and were just overtly wrongful age based acts and violated the due process of law intended by this court in Goldberg versus Kelly and Babb versus Wilkie, and by Congress and the Minnesota legislature to protect against age based deprivation during needed cancer treatment. The Minnesota courts impermissibly, and we maintain corruptly, replaced the contested July 2016 termination with a new termination, July 1st, 2017, which was strictly age based and purported to be what HSJ Longfellow recommended, but which defied the DHS order requiring new adequate notice. Respondents did this after the evidentiary hearing on the first termination, again, July 2016, and used the earlier hearing to uphold something they did later without the adequate notice. Significantly, the only reason they did it was her age, being more than 65 at the time. The July 2017 final termination was just left there in place with no payments and numerous attempts, including to this court, Supreme Court, to reactivate her MABC benefits during treatment and on appeal have been uniformly shrugged off, all age-based. The order for a new appeal with adequate notice of what the county intentions and grounds were resulted in second HSJ, Nicole Kralik, and her procedure was being set up without jurisdiction, according to the court, but having the illusion of voiding the June 8, 2017 order. The main issue of Kralik was a rumor she heard that petitioners were protesting and seeking a hearing, contesting an age-based termination. But that termination occurred July 1st, 2017, and Kralik got involved more than a month later, 2 months. The county cut off all MABC payments July 1st forever, based on her age. The second HSJ proceeding, August 24th, 2017, 2 months after the final termination, was a charade and another age-based violation of the 14th Amendment. Due Process Clause, Equal Protection Clause, Arbitrary and Capricious Clause. These developments are relevant to the rehearing for two reasons. One, they were based entirely on her age after November 11, 2016. And two, they consist of manipulation of the process to cover up the obviously unconstitutional, unlawful, reckless disregard and deprivation of federal protected interests in the entitlements of the breast cancer treatment program. And these are paid to the medical providers, not to the patient. Now, as such, as in Babb, they call for the application of Section 1983 in order to put her in the same position she was in before the age violations. That is to say, restore MABC for the duration of her treatment, and to provide for damages against respondents where that was impossible because of irreparable injury, and to provide for prospective, injunctive, and declaratory relief. To say this is unconstitutional and unlawful, and they have to stop doing it. And the injunctive also includes an impact study on the hundreds of Minnesota women who they do this to routinely. Many of them don't make it. Now, constitutional age-based violations. While respondents in the court below prefer a basis for their actions and determinations, which they say avoids a finding of equal protection age discrimination violations, they do so by invoking a right to infinitely more absolute cycle of age-based exclusion, denial, and discrimination even denying the need for adequate notice, procedural due process required by the Constitution, of the grounds, all age-based, for a hearing ordered by HSJ Longfellow's recommended measures. Specifically because of her age alone and their stilted reading of an initial requirement, they manufactured the theory that she was no longer similarly situated to other women in the program with her once she was terminated, some who were because of age allowed to continue, and some who because of their age were even allowed to complete their treatment as promised. Because of her age, in fact, respondents adeptly maneuver the 14th Amendment itself as modified through some rational basis theory to grant themselves immunity from the Medicaid Act, Equal Protection Clause, or Age Act liability. The only remedy is reversal in 1983. And this has been reversed before by the original HSJ, but they just ignore it because of fiat. Now, the government has applied a purely age-based dismissal of her clear entitlements to MABC during the time she requires the continuing cancer treatment prescribed by her doctor for her cancer. In fact, overly and overtly age-based, because the Ramsey County respondents, had to walk back their first 2016 age-based act, terminating her because, for whatever reason, they determined she belonged in, was eligible for, an age-based MAEP program, which gave her no support. The age-based injury was severely heightened then because of Schweiker versus Hogan. That's a U.S. Supreme Court case from 1982, which respondents cited as justification of a punishing burden on Social Security recipients, imposing a punitive spend down to 81% of poverty per household monthly, not just for her, but her whole household. The court below said all that money is redirected to younger MABC patients. Under the Federal Medicaid Act itself, 42 U.S.C. 1396 A3, 1396 A3, Congress also required Minnesota to set up a process for appeals, and this wasn't it, and judicial review before terminating the MABC benefits. Of course, the termination already occurred in 2016, but the point is, we did participate, as did MAP, and it was tainted. Our administrative procedure should have protected us. We're going to HHS to complain about age discrimination, could not have done that. Nonetheless, the Age Act still applies to forbid any denial of benefits in any part of this proceeding based on age, unless expressly allowed. The government has not shown it is expressly allowed. The simple initial requirement, subdivision 10A4, which says is under age 65 initially, operates with all the other parts of 10A, but only initiates the treatment coverage program. The limitations period, 10B, completes the coverage if the treatment is successful, and that has nothing to do with age. It's not an age-based program. I'll go on to part 3 in the next video. Please watch.